So good morning. We would like to start. My name is Knut Detlefsen, and I represent the Friedrich-Ebert Foundation, the Foundation for Social Democracy. And we are, inside of the foundation, the competence center for the future of work, and also in a way the trade union hub for European trade union cooperation inside of the Friedrich-Ebert Foundation. And I would like to welcome you to our conference here, The Future of Quality Jobs and Workplace Artificial Intelligence, Regulation for Innovation. So very warm welcome to everyone who participates actively in the conference, and I hope we'll have very fruitful discussions today. Especially, I would like to extend a very warm welcome to Valerio de Stefano, professor at the Osgoode Hall Law School in Canada, in Toronto, who traveled obviously very far, not only for this conference, but I hope also especially for this conference, to deliver in a minute or in 5 minutes the keynote speech of this conference. So thank you very much for coming here from Toronto. And I would also like to say thank you to our partners and co-organizers, Uni Europa, who, without you, this event, which we can say organize on a annual basis, wouldn't be possible. You're a very strong and dedicated partner. Special thanks, of course, to the regional secretary, Oliver Rötig, who will join us a little later and will sum up the conference at the end. But specifically, I would like to thank Birte Detten, who's here, who basically did a lot of hard work to make this conference possible. And I would also like to thank my colleagues, Oliver, Philipp, and Justin Nogarede, who basically put this conference together, and without them, this conference wouldn't happen. So thank you very much. So obviously, this is a very special moment, and the timing is, I think, ideal to have a conference like this in Brussels. The European Commission presented not only the Digital Omnibus Act, which I think we view critically, but also presented the Quality Jobs Roadmap. And it's, of course, very interesting to discuss what this roadmap means for workers. The EU faces weak productivity growth, and many expect that digital technologies, especially AI, might help boost the productivity inside of the European Union, even though one can also be skeptical about that. But one thing is for sure, in my view, is that the risk of misuse, like surveillance, algorithmic management, and systems that make workers work harder and not smarter, is a real problem. And EU legislation tries to balance innovation and worker protection. And that balance is under pressure right now, with calls to roll back the digital acquis in the name of competitiveness, which is the buzzword in the city. And the debate is now often framed as something like regulation versus innovation, but I believe that that is the wrong contradiction. We need smart regulation for good innovation. And I would also like to remind us that in the US, before Donald Trump became president, the last administration was actually very innovative on regulating, and particularly AI development. And so I believe that the real challenge now is how we ensure technology that it strengthens productivity and job quality, while also sharing the gains with the workers. And maybe the quality jobs roadmap is a chance, an opportunity. It identifies concrete actions to increase technology uptake while protecting workers. And this is why we want to discuss in the first panel of this conference the key takeaways from the Quality Jobs Roadmap and whether it can be a first step towards fostering quality employment, driving innovation, and ensuring worker protection in Europe. And in the second panel, we will go a step further and ask how worker protection can be strengthened in the age of algorithms and data. And we will, of course, discuss there the Digital Omnibus Act. The topic that we are discussing, and allow me to briefly talk about our competence center, is very much in line with what we do. We are based here in Brussels for the Friedrich Ebert Foundation, and we closely follow the digital transformation and aim to contribute to a future where the benefits of digital technology are widely shared and not just for the few. And our work covers a range of topics, from the risks and opportunities of AI in the workplace, but also data rights, into platform economy and algorithmic management. And therefore, I'm also very happy to say that we have the opportunity to present today the findings of two studies that we are launching. First, together with Uni Europa, we have been working for several years now on the issue of collective bargaining on AI in the workplace. And at the beginning of the next year, we will publish an update of a 2023 research providing an overview how widespread AI-related agreements, which already exists, and what key topics worker representatives are negotiating in these agreements to also serve as an inspiration for other worker representatives, but also, of course, also as a research result. The overview of these workplace AI agreements can also be found on our websites of the Friedrich Ebert Foundation and Uni Europa. And we are very pleased that the findings of these studies will be represented by the researchers from the Wage Indicator Foundation and the Central European Labour Institute. And secondly, now Giovanni Gaudio will present key findings from a joint FES Arbeiterkammer for Arlberg policy report on legal mobilization around workplace data rights, which is based on expert analysis from 10 EU countries. So we have a lot of things to look forward to, and I look forward to, of course, read the studies, but today you will get basically a preview. But now, with further ado, we will come to our keynote lecture, Algorithmic Management and EU Law, Quo Vadis. Again, I would like to welcome Stefano, who is a full professor of law. He joined the OSCODE in January 2022 and became the inaugural Canada Research Chair in Innovation, Law and Society. And he has published widely on the topic we are discussing today. And I'm very happy that you're here. But I have to say one more, I almost forgot, one more organizing view. If you notice, we take pictures and we record this conference. So if you don't want to appear on these pictures, you have to get this sticker and put it on you so that we will not cover you in our recording and in the photographs. So thank you again for being here, and Stefano, the floor is yours.
There might be PowerPoints to show. Justin? Yeah. Oh, that. Thank you. So first of all, thanks so much for the invitation. It's a great honor and pleasure to be here and to see also many good friends. Before going to Canada, of course, I was based here in Brussels, where I had the opportunity to meet and work with many of you. And again, it's very thrilling to be here. Now, I came from Canada, I arrived from Canada, but I am very much Italian and European. So I am very much invested in what I'm going to say today. It's not a look from the other side of the Atlantic that is detached. And it is a look that is quite concerned about the recent attacks that Elon Musk and the American administration have levied on the EU. Recently, the new strategic document issued by the White House that basically aims at dismantling the EU institution. And this is something that the new American administration shares with the tech companies. And Elon Musk has made it clear that after his recent fine, his new target is going to be the EU. And it's important for us to realize that the attack on the on the rule-based international order that the EU represents, together as many other international institutions that at the moment have seen funds withdrawn and other forms of attack from the American administration, is not just about public international law, it's not just about the UN, it's not just about the International Court of Justice, but it's also about, crucially, who gets to regulate tech. It is crucially about who governs our society writ large. It's not just about public law, it's also about private law. It's also about, crucially, I'm going to say in this presentation, it's also about workplace law, the law that we apply in the workplace. Major tech companies don't conceal anymore the idea that they consider themselves above European supranational democratic institutions. They in many cases, they want to bargain from a condition of superiority with democratic elected governments, and don't question anymore the opportunity of single provisions in a certain piece of regulation. They question the legitimacy of regulation in itself. The idea is that any form of regulation that they don't like stands in the way of their supposed mission, and it is framed as an illegitimate interference rather than a product of democratic self-regulation from democratic societies. This vision is now happily endorsed by the new American administration that is quite aligned with what the tech companies, especially the ones that are based in the US, purport to do. And there is a sort of siege that is laid from that side of the Atlantic, but also from the inside, with a strange alliance between Europopulist parties, nationalist parties, extremist parties, and of course, what comes from the other side of the pond. Now, the target here is really what the EU and democratic national states in Europe represent, a society based on the rule of law and on the idea that all people are equals, an idea that is not necessarily shared, but by all the other subjects that I mentioned so far. Some of the ideologues that shape the views of the tech companies and the Trump administration have very alarming views around the rule of law, but also around society based on equality. They purport and propose a new vision of polities that is based on inequalities, race-based inequalities, gender-based inequalities, crucially also social inequalities, a distinction between the have and have-nots, and those who have agency and those who shouldn't have agency. Curtis Yarvin, I don't know if anyone has heard of him, but he's an activist, very influential. Someone was the heir of Vice President Vance and of Peter Thiel from PayPal and many other and many other initiatives around the globe. Of course, eminence grise of the far right around the globe. Has long advocated for the destruction, the eradication of supranational institutions and democratic national governance to be replaced by private city-states run by CEOs. The idea is that in these city-states you will not have political rights. You will not have a right to a vote. You could not challenge the views of the CEOs or overlords of this small states society. The only thing that you can do if you are unhappy is to leave. And now this brings me to why in the heart a labor lawyer is interested in all this. Because exit no voice is a mantra of the neoliberal thought around workplace relation and has been a mantra in this field for over 40 years. Workers should not have rights at work. They should not be able to challenge what the management has decided. If they are unhappy, they are free to go. We cannot keep them at work unwillingly, but other than that, you should not have rights. You should not have a claim. You should not have a voice. This is a clear piece of alignment between that neo-reactionary agenda and what is happening in workplaces, especially in the other sides of the pond, but sadly, we are seeing some of this also on this side. There's many anecdotes that one can summon up. By the way, Curtis Yarvin was also the first in this world to say that we should fire all public civil servants. So if you work in any European institution and now you are concerned about the new plans about your jobs in the future, there's also another person that you can thank for that. It comes from that strain of thought. And the Doge activity in the US, the firing of all the civil servants in the US that we've seen last year also comes from this strain of ideology. Now, again, there are many anecdotes that one can share, but I think that one crucial is Marcus Anderson, who is a venture capitalist active in the field of tech, gave an interview a couple of months ago and said the Democrats, the Democratic Party in the US, lost the Silicon Valley when we realized that we could no longer control our workforce. And after 2020, when people started to claim and to demand that the tech companies in particular would stick by their value and, for instance, implement seriously diversity, but also acknowledge their impact on society, when our employees started to, he says, make a revolution in our companies, that's when we decided that we could no longer support the Democrats and we had to shift and to go somewhere else. This is where we decided we had to support the Trump administration. It is about the workplace. The workplace is a fundamental tenet of society, as I'm going to talk about in a moment. And the workplace is a fundamental tenet of society, and labor law, the law that regulates the world of work, is also a fundamental bulwark against abuses of authority that stand in the way of the rule of law in our society. Labor law is crucially one of the fundamental ways in which the rule of law gets in the workplace. We are in the workplace and we are protected. We are not subjects, we are citizens, because there's labor laws that protect us from abuses of authority that come from abuses of potential managerial prerogatives. This is because the law in the field of work doesn't just set down protection. The law is also setting powers and authorities and giving them in the hands of employers. Employers have the power to direct their workforce, to monitor their workforce, to discipline their workforce. And all this power and authority is not something that is just out there in society. It's the result of legal choices. It's the result of policy choices. It's not natural. And it's also unheard of in other contractual relations. Your landlord cannot tell you what you wear, even if you are in their house, right? Your employer could tell you what to wear in your workplace. And your employer can also exert authority on many aspects of your life that have nothing to do with your work performance. Think of all the persons that get in trouble with their employer because they write something on social media that they shouldn't. In many cases, they really shouldn't write those things. But it is a percolation of authority from the sphere of work to your own personal, private sphere. Now, labor law is there also to make sure that authority at the workplace doesn't stand in the way of running a democratic society. The idea is that you keep on being a citizen when you are at work. In my country, in the 1960s and 70s, when the labor movement was campaigning for protections like that, from strong trade union protection at the workplace, their campaign was the Constitution inside the factory. We have to bring the Constitution inside the factory. We have to bring the rule of law inside workplaces, because otherwise we are subjects. We are not citizens. If we are not protected in our ability to express a voice, in the ability to not, or the right not to be discriminated against, and many other rights are not just economic rights, they're also fundamental liberal democratic rights. The problem is that, and we have to ask ourselves whether our labor laws that were conceived with the objective of keeping the rule of law up in the workplace, well, are they keeping pace with what's going on in our workplaces thanks to technologies? We see, and we will learn more today thanks to your fantastic studies, how technology and certain types of technologies are spreading in the workplace. And many technologies that we can summarize under the label artificial intelligence and algorithmic management. These are, in many cases, buzzwords, but you get the gist. Well, many of these technologies fundamentally shift and change the balance of power within workplaces. That balance of power, that was the primary objective of the labor laws I've been referring to. I will not go too much in detail here because we are going to hear about this much more in detail, but this is just some examples of the ways in which technologies are being used at the workplace to hire people and also in the pre-hiring phase, directing workers, monitoring what they do with GPS, RFID technology, keystroke tracking, emotional surveillance, whether through collecting data about your Fitbits or collecting data about your browsing history. The idea is to use predictive technology to understand whether you are on the brink of doing something that the employer may be interested in. Maybe you want to unionize, maybe you are planning a parenthood, maybe you are planning to quit. Your employer in many cases will know, in some cases before even you know, because of the data browsing search that you are putting in the devices that they have provided. And many of these things then go to and are used in discipline. Many people find themselves in trouble with their employer because these systems give results that in some cases are very skewed, very inaccurate, because there is no loop, there is no feedback between the users of the technologies and the programmers and producers of these technologies. And you can get fired or disciplined because the system thinks that you are not performing up to the level that the system wants you to perform. So if you are, I don't know, an Amazon worker and don't pack as many boxes that the system thinks that you should be packing in 10 minutes, you can get in trouble and you can get the sack. And this is just one example. These technologies, and again, we're gonna hear much more about this in the next presentations, they augment, they make managerial prerogatives much more powerful because they subject people to continuous, relentless control. Before these technologies came around, it was impossible for an employer to follow you every second of your workday, which is something that is now possible. Thanks to GPS, thanks to computer technology, your employer can know what you're doing second by second if they want it. These technologies also replace human decision-making or complement human decision-making. Managers get told which workers are the productive ones and which workers are the slackers. And because of the way labor law works and because of the way workplaces work, and again, because of all the authority that is in these workplaces, no manager is gonna stick their neck out and say, oh, this system that we bought for a gazillion euros told me that this person should be fired, and I'm gonna stand in the way of that. Workplaces don't work like this. Managers will not speak out against systems that they, even when they perceive that these systems don't work. It's gonna be very rare that this happens. Algorithms are mistakenly deemed neutral. They are mistakenly conceived to be without discrimination. We all know, and now there is a huge literature about discriminations that can occur through algorithmic management because the data sets on which the systems are based is trained wrongly, or the data set includes biases in the dataset history, or because the prompts that the programmers have included in all these systems. They also go much more in depth than other forms of surveillance go with the attempt of using predictive technology and emotional surveillance. And they also extend beyond employment per se. We have seen that this has been applied to platform workers for ages now. So it's also about certain forms of self-employment. It's not just confined to the employment relationship. That's why we need upgrades of labor laws. Labor laws are not keeping pace, this is my idea, with all the things that I have been discussing and will be discussed today. Now, one of the fundamental ways of doing this is to strengthen privacy law. All of these technologies are heavily reliant on data, so it's crucial to understand how data can be collected and processed. However, we have the problem that many privacy instruments, the GDPR, are horizontal. They don't go in depth in the workplace. They are not conceived for the workplace. They are, in many cases, conceived for customers. They don't take into account the imbalance of power that is structural and it's presented in workplaces. That's why, for instance, consent is not a meaningful legal basis in the workplace, because if your employer can tell you what to do, you being able to say, no, I don't want to be treated in this way, I don't want my data to be collected in this way, well, that claim is basically meaningless. We now see that the digital omnibus wants to expand legitimate interests. The idea is that the digital omnibus will not affect technologies or provisions that affect the employment, but we know that it's very, very difficult to draw a line. So when we expand legitimate interests for employers, they are gonna probably use it also to to process and collect data in ways that they were not allowed before this omnibus would pass. That's why it is essential that we enrich, that we include in the DNA of privacy regulation fundamental labor law institutions and concepts. The GDPR already offers an opening with Article 88 that opens to the member states to use collective agreements and labor regulation to complement and support privacy at work. But I think that we are now at the moment in which we also have to be creative in how we can use the GDPR. And one of the ways in which I think we have to use it is to fill the gaps in the GDPR and the open clause in the GDPR with labor law standards. And I can give you an example. The GDPR, in many cases, uses open-ended terms like fairness, proportionality, necessity, data minimization. And so what does it mean? Well, after the Platform Work Directive has been approved, my thesis is that we can use the Platform Work Directive as the benchmark to say that what's contrary to the Platform Work Directive in the platform sector should also be deemed against the GDPR. If something is considered to be disproportionate under the Platform Work Directive, it cannot be proportionate under the GDPR. And fairness is the same. An example, the Platform Work Directive bans outright the use of or the data, the collection or processing of data on emotional surveillance, on collecting our data after working hours, on collecting data about private conversations, collecting data about the intention of exercising fundamental rights. Do you want to unionize? Do you want to go on a strike? Those data cannot be collected or processed under the Platform Work Directive. Well, it doesn't make sense that this only applies in the platform work sector. In the same legal system, we have to apply consistent set of rules. So anytime that we see these practices that are banned under the Platform Work Directive applied in workplaces that are not platform work, we should probably raise the flag and say it is impossible that the GDPR allows this, because now we have some industry-specific standard that we can operationalize also beyond the platform work sector. This is my idea, again, because we cannot have inconsistent set of rules for the same area, which is the area of work and employment. But very importantly, this is not just about privacy. All the technologies that we have discussed and we will be discussing later on affect many other fundamental rights of people. They affect your right not to be discriminated against. They affect your occupational health and safety, because if your algorithm can tell you to pack too many boxes in a day, then you're going to develop diseases. If you're followed around every second and every minute of your life, you're going to develop psychosocial risk and stress. This is going to also affect your occupational health and safety. This is going to affect your freedom of association. If your employer can know in advance, can predict that you want to unionize or you want to engage in collective bargaining or go on a strike, they're probably going to do something about it. And even if they are not, your idea of doing that, to go to the union, to go on a strike, will be chilled, because you know that your employer, in many cases, will know even before you have reached out to your colleagues. Individual protections, which are the way in which privacy laws are organized, are not enough. The workplace is an intrinsically collective environment, and labor laws are intrinsically collective. They aim at the managerial prerogatives of employers, which are intrinsically collective. The employer doesn't give orders individual by individual in many cases. They give collective orders. This is why labor law also operates at the collective level. We have seen some examples of collective counterbalances when it comes to technology, the new strains of technology at work. Again, the Platform Work Directive introduces the right to information and consultation when it comes to automated decision-making and algorithmic monitoring. The AI Act also establishes a vague but existing right to information when AI is deployed at the workplace. German law has been more or less recently amended to include the co-determination rights when AI-based electronic monitoring is introduced. So there's examples that we can operationalize to foster collective rights to react to the abuses of technologies that we see in our workplace today. My idea is that we should take these collective rights seriously, and we should extend co-determination and collective bargaining rights to technologies the same way in which we have done for many other technologies in our workplaces that are much less invasive than what we see today. In many countries in Europe, in order to install a video camera in a workplace, you have to talk with the Works Council. You have to get an agreement. This is not the case under many of the existing standards, unfortunately. So we have more protective standards for less damaging and invasive tools. This is a paradox that we should solve. But also, crucially, it is not just a matter of privacy, because algorithmic management deals with and determines your pay, your working shifts, your working hours, the way you can be disciplined. Now, these are all collective bargaining topics. Pay is a crucial collective bargaining topic. Working time is a crucial collective bargaining topic. The fact that is now, all of these things are now determined by tech cannot be used as a smokescreen to say, well, we are not negotiating anymore on all of these things because it's the tech that takes care of this. It's not the tech, it's the employer that takes care of this through technology. Tech per se doesn't do anything. Whenever we renounce, whenever we step back from negotiation of these items, we are in a way hollowing out collective bargaining. The other thing that labor law and labor lawyers have to do is also go in depth in themselves and think about the legal and analytical frameworks that we have been using to justify the deployment of technology at the workplace. All our analytical and legal principles were conceived at a time in which technology was about things, was about machineries, was about an assembly line. It wasn't about people. AI and algorithmic management are technologies that affect people, not things. We cannot use the same analytical frameworks for employers to basically being able to deploy any technologies that affect people in the same way as they were free to use technology to affect things, because those are not the same thing in a democratic society. Quite crucially, this is also about sustaining democracy at work. If we hollow out collective bargaining at work, and collective bargaining has long been the way in which you become a citizen and not a subject at work, well, if we hollow out collective bargaining, we are also hollowing out the rule of law. We are also empowering employers to take decisions that they should not be able to take in a democratic society. We should be very wary of allowing this hollowing out of collective rights. And this brings me to the conclusion of my talk. The conversion between the tech companies, certain tech companies, not all tech companies luckily, but certain tech companies and authoritarians this side of the pond and outside, is about having a meaningful regulation of technology in our society, and for what matters today, a meaningful regulation of technology at work. And this is not a case. There is studies that have showed a correlation between a lack of autonomy and agency at work and the support for extremist parties. If you are told every day at your workplace, that you are not able to make decisions because someone else is going to do those decisions for you, and someone else may also be a machine, well, you're not going to entrust yourself to make meaningful decisions when you are in society. You are going to support authoritarian leaders that make those decisions for you. There's many thinkers and also increasingly data around this. When we start talking about this, I completely understand that the buzzword of productivity and innovation is quite strong at the moment, but we also have to realize that we are not just here to talk about that. We are also here to talk about citizenship, democratic society, and the rule of the rule of law at work and in societies. People spend most of their waking lives in their workplaces. It is impossible to think that what happens at work doesn't affect democracy at large. We must realign that the regulation of digital technologies with fundamental rights at work more than we've done in the past. We must not retrench. If at all, we have not done enough in many sectors. And we have to do that because, again, labor law has been and is still an essential tool to make us and to preserve our citizenship rights at work. We should not be treated as subjects or data subjects. We should be treated as citizens, and this is why we need meaningful employment and labor regulation. Thank you very much.
Yeah, thank you very much for this very political lecture. And now we have the opportunity for some questions to Stefano. So I invite you to ask questions. But do these work?
I think that should work. Yes, sorry. Thanks a lot, Valerio. That was extremely interesting. I really like the link you made also with authoritarianism, because I think that's a big development that we see. And also at FES Future of Work, we supported a publication from Francesca Bria called The Authoritarian Stack that exactly goes into that nexus of extreme right thinking, technology, the US government, frankly, and how we use that technology in Europe and how that changes democratic norms, debates, and values here in Europe. Given that, I have one question. I totally agree with the importance of regulation, that we should make sure that we apply the law, that we defend our values around the rule of law at work. At the same time, I feel we're not really doing it and it's not really working. Like for me, enforcement seems to be such a missing topic. Like how do we do that? Because we all use those technologies from the US. They often are sort of optimized for different types of principles, right? Not data minimization, but data hoarding. So how do you look at that? Like how can we strengthen this enforcement? Because we have come up with many laws in the recent past, but I feel that the situation on the ground is still pretty dire. So that would be my question to you. Thank you.
Can we take one more question?
Of course.
Okay, thank you. Simon Vindje from Sweden. Thank you very much for your presentation, and you really put the finger on, how all these powers work together, which is very interesting. So I work for a trade union, and the challenge we have at the moment is that even when we know, it's very hard to prove. We know the surveillance and we know how the data is used, but to prove this and to use it in when we fight back, it is really, really hard. So a comment and maybe a question. Thank you.
Can I answer and then go back? Yeah. Okay, thank you very much. These are excellent questions. And I think that my answer is going to be linked for both questions. Justin, one of the problems that we see in technologies today is not just that there's a lack of enforcement of regulation, but it's also that these technologies don't work. That in many cases they are not more productive. That in many cases they stand in the way of productivity because they are not conceived by the people who deploy the technology. They are not conceived by the workers. They are conceived by programmers that in many cases have absolutely zero idea about what a job is like. There were cases in the US in which doctors were sanctioned because the computer that was tracking what they were doing thought that they were not at work when they were speaking with patients because they were not at their computer. These technologies are not conceived by the workers. And this is a big problem for employers too. This is why collective bargaining is essential, because workers know how the workflows work and can give feedback and can also say this technology is helpful, this technology is just detrimental. The idea is that, unfortunately, the idea that has been driven to us with all this quest to innovation, etc., is that as if there was one part of the world that knew everything, and the people that do the things don't know how to do them. The workers don't know. They should be told what to do by some geek in the Silicon Valley. Unfortunately, that is not how the world works. If you give the decision-making power to people that don't know anything about a certain industry, company, or work, then nothing good can come out of this. So collective bargaining, co-determination is also a way of giving feedback to your employer about your technology. This is why, in my opinion, it's an efficiency driving thing to ensure and enforce and strengthen collective rights. So when you say, and collective bargaining is also a crucial tool for enforcement of fundamental rights. We all know that when you have a work council, you are better protected at your workplace compared as to where you don't, okay? Everyone knows that. And how do we know? That's the problem. It's how regulation needs to help us. We need to have more stronger data, stronger access to data, thanks that is mandated by regulation. We need to make sure that no technology that affects people can be concealed behind trade secrets and IP law, because that's not how technologies that affect people work. The pharmaceutical companies cannot say, we're not going to tell you what's in this medicine. Maybe they can bargain for a patent, but that's a completely different thing, as opposed to, we don't tell you what's in this technology that determines who we are, how you get paid, how you get disciplined. This is something that we need regulation to foster, and unfortunately, I'm not sure that privacy law per se can be helpful unless, as I said, we include in the DNA of privacy law some fundamental labor law tenets. Your employer cannot tell you at the moment, we're not going to give you data on our budget when we are negotiating salaries. Am I wrong? Because you need to know what's the situation of the company if you are negotiating salaries. And the same thing applies to technology, or should apply to technology.
So we can take a few more questions.
Yes, thank you very much, Valerio. Ilkka Penttinen Foutu from Eurocatres's side. Firstly, great overview of the situation and great questions already. I'm going to touch on those. And one thing which you were mentioning, it's quite a lot about trust. All in all, like we are talking about this artificial intelligence revolution, and we want to see that that's of course reaping the benefits. And at the same time, it's the MIT had this fascinating study from the US where they are pouring something like $60 billion on artificial intelligence uptake on different organizations, and 95% of those initiatives are failing. And one of the key elements there is trust, like people who are actually trying to use them. They do not trust the systems, they have not been involved, rather than there's this top-down implementation of the systems, and that's failing. Now, that's not actually what I wanted to talk about, but just a quick reaction on this, that this is actually also fundamental for the industries to be successful, and why the European social model should be actually benefiting quite a lot, also the AI uptake. But I'm quite curious now, touching on the enforcement side of things, because something that was asked upon a bit before is that it's quite a lot about enforcement, but it's also quite a lot about the collective data rights. Like I feel that this is, especially when we are talking about the underlying issues, what's happening with the omnibus and with GDPR at this very moment, is that the privacy rights that we have, they might be actually more influential in the workplace scenarios than we have even foreseen, and they have been underutilized in quite a lot of ways. So this is sort of a question, like how we can actually like take steps forward on the collective data rights, because I think like this is something that, especially in the Swedish case also, that we are very curious to see that where we can utilize, where we can get better on using this, because that's going to be also the future issue, because this use of algorithmic management is only going to be intensifying in the upcoming years.
Good morning, Fatma Güneri, Associate Professor in the Université Catholique de Lille. I have a question about co-working. Companies are more and more copying these co-working space models, which is more popular since Jeremy Rifkin's approach. To your opinion, companies are very interested in these co-working models because they want to increase the collaboration between the employees, or they are interested in this more because they want to survey better the employees in open spaces?
Sure, of course.
Good morning. My name is David Espinosa from Europa, Director of EU Affairs. I have a question about the EU model of doing technology. There's this new wave at the European level of creating the social and the capitals union to create a venture capital market for EU startups, and now we have a 28 regime because they want to replicate a little bit, I think, the way that Silicon Valley grew, and they have this idea of creating the European startups. But at the end, my fear is that we are not questioning the model that led Silicon Valley to where it is now, and try to create, just replicate the model here in Europe could create the same end result. So I'm wondering if you have a proposal on how to create a different model here that just doesn't replicate what happened in Silicon Valley 30 years ago.
Okay, thank you. And again, very, very interesting question. Let me start from the last one. I am a labor lawyer. I'm not an expert in all of this investment driven technology and regulation. My sense is that the Silicon Valley has been developed, and it sits where it sits because it was very convenient to have a pole in which you could use research and development for the military industry. Okay, this is what has driven this is why the Silicon Valley is there, basically, to serve the military and to serve the biggest, wealthiest military in the world, not just one military. All the discussions that we do around here is like, oh, we don't have that Silicon Valley because there's the GDPR or the AI Act. This is complete poppycock, of course. We don't have the Silicon Valley because we don't have that tech drive. And maybe it's also good that we don't have it. It's a debate that I cannot solve today. But the idea of shaping our way of development on that particular model, as a comparative, the only thing that I can say is that when you try to basically transplant models that have nothing to do in a new scenario, you're doomed to fail. So I don't think that you can do that in the same way. We definitely have an issue with venture capital in the EU. There is not enough venture capital that funds technologies that we know are not going to necessarily to work. There's a lot of risk aversion in financial investment. The US also have the dollar, and the dollar is the currency of the world. The euro, unfortunately, is not. So they are able to leverage that in ways that the Eurozone is unable to do. So there's many things that sit into this answer that cannot be just solved by saying, oh, why don't we open a Silicon Valley in the north of France? This is not how it works. About co-working, I don't have particular insights. I mean, I'm old enough to remember 10 years ago when there were people saying, "Oh, we're gonna all work in co-working space in the future." That has not necessarily materialized. I think that with the pandemic, we've seen an increase in remote and hybrid forms of work, but now how to balance this with organizational processes and workflows is a discussion. I'm not sure, I don't see enough pallets to allow people to work from wherever they want for the entire duration of their working life at the moment. What I see is probably the palette to say you should only be freelancers so you can work from wherever you like. And that's something that is potentially problematic. So if co-working is a way to create a community in peripheral neighborhoods, that's all the better. If it's a way of saying you should not be employed, you should just work as a freelance, why should we employ you and give you an office? I am more skeptical. I don't have a specific answer to that. And to about the first question, you mentioned this study from the MIT that says that up to 95% of AI pilots then are put back in a drawer, never to be used again. And this is one of the problems is that, again, these pilots are conceived and they use technologies that were programmed by people that didn't know how the company worked. And so you talk about trust, and it's a problem of trust because workers and managers see that those things are unable to help them with their workflows and actually make things more cumbersome for them because you have to go around the technology rather than using the technology to help you. So there is a huge loss in productivity. And again, this can be fixed if you have a meaningful feedback with your employees, which can come from collective rights and employment, collective rights and collective bargaining. The problem that we have, and you mentioned also the privacy rights and why haven't we used those enough? Yes, it is still, we are still at the beginning of, we're still seeing some interesting initiatives to leverage privacy rights. The problem, however, as I said, is that privacy laws were not conceived with labor in their mind. They were not conceived with workplaces in their model. There is no labor by design in privacy. So again, in order to better leverage privacy laws, we have to understand how we can make privacy laws more adherent to the way in which things work at the workplace. At the moment, this is not the case.
All right, one last question.
Marvelous. Oh, thank you. Thank you so much, Valerio. Extremely inspiring. I'm very happy that you're here at FES and Uni-Europa's conference. And my question has to do with your reference to and your encouragement to think about looking at the kind of context-specific Platform Work Directive and taking some of the principles transversely from also existing GDPR. And then the list was clear. You have data minimization, proportionality, fairness, and necessity. So my curiosity is in terms of the coherence question, which I think is a big one, and you've referenced it to think in terms of labor law and technology law. And I'm wondering if you have something to say about the trend towards use of technical standards and this kind of question around harmonization and the adaptation now as it's happening with the authoring of the standards toward incorporating bits of private law into public kind of questions in public law. And if there's something at stake, and if that kind of links, I think, with the diminishment of this potential utilities and strength for EU law for labor law protections in the technology space. So thanks.
Thank you.
Just a small one for the, yes, we go into coffee here.
Yeah, but make it short.
So my question, Valerio, and it's very nice to see you, is about the collective bargaining on AI in the workplace. I think you're right that it's a really, really vital way to frame it. But my question really pertains to the fact that it's very hard for trade unions to actually meaningfully do that because often the technology has advanced at such a rate that they're not even really able to understand it or have the knowledge about how to actually negotiate on it or what it meaningfully does. And they're entirely at the mercy of employers to give them that information. And that is where you can sometimes, like in my own sector, I represent the International Federation of Actors. Only the biggest, strongest unions were able to actually do the work of gathering information also from third-party sources to actually be able to negotiate on the use of AI. For smaller unions in Europe, it's beyond what they can actually meaningfully do.
Thank you. I think that I answered first to the last question. Thanks so much. The problem is that in many cases, employers will not know because they are not the ones that have created that technology. They are just deploying a technology that they have bought or leased for someone else. So they cannot answer you because they won't know in the first place. But the problem is that in doing this, they are deploying things they don't understand. They are sitting on a mountain of potential liabilities that they also cannot fathom. So better regulation and better information duties in this area is not just about being nice to workers, it's always nice to be nice to workers, but it's also about protecting firms from a model that is exploitative also to them, not just to workers. That is not a solution, it's just a way of looking at this thing to campaign for better regulation of these things before they get deployed in the workplace. And Phoebe, the last question. I think that, of course, when you have many technical standards and many different regulations across the board, it's difficult to find coherence, right? But it's still possible to try and influence that. The first version of the AI Act, the ones that was leaked at some point before it was made official by the Commission, was a disaster from many standpoints. And then even the people in DG Employment had to go to their colleagues in the other DGs and say, what are you doing? This is going to be a disaster. And just by saying that, just by introducing those considerations in that design, they managed to avert some of the worst things that could have come from the initial proposal. So we can do it. It's not like we are not doomed to fail by definition. We can still do. We have agency. It's just a red herring to say, oh, there's nothing to do and there's nothing to do around technology. These are things done by human beings. We can control them. That's my last and final message.
Thank you very much, Professor De Stefano, for this excellent start of the day. Very inspiring, very thoughtful, and very, very on topic. So now we have the opportunity to chat a little bit over a cup of coffee, like a 15-minute coffee break, and then we will continue the discussion with our first panel, where we'll talk about the quality jobs roadmap and assess its usefulness. Thank you very much for being here.